Hi everyone, and welcome to the substantive topic Basic Negligence for Tort Law, or if you prefer just negligence. This is actually going to be the third time I try to record this because of some audio issues, so hopefully it works out fine. If you find this video useful, please like and subscribe. So starting off, as we move in, we're dealing with AQA law. On my course, we move from criminal law to tort law, and we have to understand, of course, that the terminology changes as well. So who is the burden of proof on to prove their case in tort law? In other words, who brings the case? It would be the claimant for civil law, and tort law is, one area of the law within civil law. So it would be the claimant that brings the claim. In this instance, negligence. What is the standard of proof in a civil case? Now, it's a lot less than criminal law because the consequences are a lot less. If in criminal law, if you're found guilty, you could potentially lose your liberty. You certainly are left with a criminal record. So it's not beyond reasonable doubt, but in a civil case, it's on the balance of probabilities. So the claimant just has to be more, persuasive with the evidence, before the court in terms of arguing their case. If you want to put it into a sort of a number, you could say 51% more convincing than the other party, the defendant at least. So broadly speaking, if you're establishing as the claimant a claim of basic negligence, the claimant will need to prove three things: that the defendant owed them a duty of care, that the defendant breached that duty of care, and lastly, damage. Damage is the equivalent of causation in criminal law. So in other words, you as a claimant have to prove that the defendant's act, or omission if you will, led to you suffering personal injury or property damage. Now, it all began with a snail, funnily enough, in one of the most famous cases in law called Donoghue and Stevenson from 1932. And if it wasn't for this case, we wouldn't have tort law as we know it today. So the case facts here is that Mrs. Donoghue and her friend went out for a drink at a cafe. Her friend bought her a ginger beer. Now, the bottle itself was opaque, which means it's not transparent, it can't be seen through. And it was only until Mrs. Donoghue started drinking the ginger beer from the bottle that she quickly discovered that there was a dead, decomposing snail inside the drink. Now, obviously, she suffered personal injury. I think it was gastroenteritis, and she wanted to, be compensated for this. Now, the issue there at the time was it was something typically that would be dealt with in contract law. Now, of course, the problem being Mrs. Donoghue didn't have a contract with the cafe for the drink because she didn't buy it. The friend had the contract, and the problem there is the friend didn't suffer the damage, the harm. That was Mrs. Donoghue. So this was very much a test case, a landmark case. And ultimately, the court, led by Lord Atkin, reached a judgment that said, yes, a duty of care should exist and can be imposed in this instance on a manufacturer to ensure that drinks produced are safe. And we can see in the case of Donoghue by the House of Lords that it began with asking, who is my neighbour? This neighbour principle was established, and it used Christianity as a basis really to answer this. So the most famous of quotes, my neighbour is persons so closely directly affected by my act that I ought to have them, reasonably in my contemplation. So if we were to apply that, for example, to a driver in a vehicle, in a car on the road, should have in mind that their actions could directly affect, for instance, if they were speeding or careless in their driving, would directly impact, say, any passengers in the vehicle, as well as any pedestrians potentially around them, as well as any other vehicles. So this established the existence of a duty of care. But what we want to do is move forward to the current legal situation, because, of course, in the exam, I'm talking the AQA exam here, for the A level, you really wouldn't be expected to talk about Donoghue and Stevenson from 1932. That was the starting point, but there has been further development of when a duty of care should exist. So the case I think you really ought to begin with is the case of Robinson and Chief Constable of West Yorkshire. Now, this case is useful on two fronts. The first is the Supreme Court confirmed the position, and it makes reference here to Caparo and Dickman. I'm going to do that in a moment. But Caparo and Dickman, a case from 1990, really was used, or thought it should be used, to determine whether a duty of care should exist. And the Robinson case by the Supreme Court held that that is not the case. The position is that if there is an existing duty of care in common law or statute law, or a similar one, then that is what should be applied. And it's only if it's a novel situation, a situation never faced before, should the courts then use the three-part test in Caparo and Dickman, which we're going to go on to. So that was the first thing that Robinson case is useful for. The second point is that it was held, or thought to be held, the police don't owe a duty of care to anybody, that the police couldn't owe a duty of care to anyone. And that's because of a previous case called Hill, which we'll talk about. But what we've got here, if we talk about the case facts, is the police were surveilling a suspect, trying to determine the best moment to apprehend him so that it wasn't a danger to the public. He went into a betting establishment at one point. They held back because they thought that would pose a danger to those inside. And then when he came out, they then tried to apprehend him. And unfortunately, this elderly lady you can see on the right actually was coming along the road, and as the defendant was trying to the suspect trying to break free, they sort of bundled into her and she suffered harm. So the ratio decidendi here is that the police do in fact owe a duty of care if they have created a dangerous situation. And I think that's fair and right and proper. So to go back to that Caparo and Dickman case from 1990, this is now really used, the three-part test, if we put it on the screen. If we're unsure and there doesn't appear to be an existing or similar duty of care that can be found. So in an exam situation, if there really is nothing there that you can think of, then safest bet is to apply these. To give you an example, if the exam scenario said that you had say a surgeon and their patient, you would know that a surgeon's duty of care to their patient is to ensure their welfare. So you wouldn't need to therefore go through these three tests. You can just refer to the Robinson case. But like I said, if it's unsure, unclear, use these. All three tests have to pass if a duty of care is to be created by the court in terms of precedent. So firstly, was the damage or harm reasonably foreseeable? The case of Kent and Griffiths. In this case, person was suffering a medical emergency. An ambulance was called, but the ambulance was late, and therefore the harm or injury to the person seeking that medical care was greater, because we know it's reasonably foreseeable if you don't receive medical attention quickly, then potentially, if it's a life a sort of very serious situation, medical matter, that could be worse. Now the second thing is there a sufficiently proximate, or if you prefer close relationship between the claimant and the defendant? We see a very similar test again in the next topic called psychiatric injury. But if we relate this to the case of Boar, Hill and Young, in the case here you had a motorcyclist, I believe was speeding, crashed and died. Mrs. Boar Hill didn't witness that crash, but came to the scene thereafter. Mrs. Boar Hill was heavily pregnant, and she saw some blood on the road, as well as I think some strewn bits of clothing from the deceased, and so she knew something terrible had happened, and the shock of that moment led her to miscarry. She lost her unborn child. Now, interestingly here, the courts were not prepared to accept a duty of care existed, I think for a number of reasons. Firstly, of course, the motorcyclist wouldn't have had her in reasonable contemplation. But secondly, and I think this is the key bit, I think Mrs. Boar Hill, didn't know the motorcyclist either for the claim that she was trying to apply there. So this is an example of the courts limiting when a duty of care should exist. And we see that again with the third and final test here. Is it fair, just and reasonable to impose a duty? So if we take the case of Hill, what we have here is the serial killer, Peter Sutcliffe, otherwise known as the Yorkshire Ripper, terrorised the police for years. But at this point, they knew, his identity. They had evidence that he was in fact a killer, but they didn't yet apprehend him. And unfortunately, Mrs. Hill, who brought the claim, her daughter died, I believe was the last victim of Peter Sutcliffe. And so she blamed the police, thinking that if they had acted sooner, then her daughter would be alive. And interestingly here, the court wasn't prepared to impose a duty of care on emergency services, but certainly the police, because they felt that this would hamper their job, that the police are there to detect and prevent crime. Of course, they can't prevent everything. And so if the police were suddenly able to be sued in pretty much any situation where they hadn't prevented a crime, then again, they thought that this was just too much. So I think overall these three tests, and particularly the last one we just discussed, this is the court's attempt to limit when a duty of care should exist for public policy reasons, to prevent the floodgates from opening to too many claims that could, affect people. So if all three of these tests pass, the courts will create a duty of care. Or if, as I said before, you've got an existing or similar one in common law or statute, then the claimant's established a duty of care. But we're not yet done with the full claim of negligence itself, because if you remember, duty of care is but one thing. We need a breach and we need damage. One thing I like to ask my students, that's me of course, is does your teacher owe you a duty of care? If so, in what situations? When will these be breached? And does a teacher owe a duty of care towards you performing well in the exams? And of course, students for the first one would say, your teacher does owe you a duty of care. Again, it's about the welfare of your students. So for instance, if a fire alarm goes off, I'm not just going to walk outside of a classroom and leave my students in there. So that would be an example. More recently, you've got the statutory example of female genital mutilation, FGM. So teachers now, if they suspect that that is going to happen or has happened, have to contact the police immediately. And you can see in those instances there, when will these be breached? It could be through an omission, essentially. So again, another situation in the classroom could be if I see a student, standing on top of a chair to reach the top of the whiteboard as they're writing, and they're balancing and quite precarious. If I say nothing and they fall, then there's a strong argument that I've breached my duty of care. The third point of whether or not I owe a duty of care towards students performing well, interesting, get a number of arguments here from students, but I'm going to share this with you. A graduate, in fact, from Oxford University tried to sue the university for £1 million because he failed to get a first in his degree. His argument being that, had he got a first, he would have had an even more successful career and earned even more money. And really laid the blame of negligence at the university for the bad teaching, if you will. Now, Mr. Justice Foskett, in this case, based on the evidence that was presented by the claimant, wasn't convinced that there was negligence proved, even though the university accepted there were fewer teachers as normal. Interestingly, there was no medical evidence put forward. So at the time, the claimant, claimed he was suffering from depression, insomnia, and such. Had never made the lecturers at the university aware of this, and so again, his claim wasn't established, and he lost his case. We've got another example here, Malvern St James School, Girls' School. Now, they in fact taught the wrong exam book. So here, a £37,000 a year independent girls' school, their teacher taught them the wrong text for the English literature exam, so that when they went into the exam itself, they couldn't possibly answer those questions. The exam board said thereafter that they could request special consideration, and the school were very apologetic. But there's an interesting argument there as to whether or not here could be a situation where a student could sue, and there's some, certainly the school's admitted fault. Should parents be able to sue over poor exam results? Well, 3 teachers give their view in this Guardian article, and you may want to click it and give your own view. So, having done duty of care, we then move on to breach, the next part of the claimant bringing a claim for negligence. So what is the test for the court? The test is, does the defendant's standard of care fall below what is expected of a reasonable person? So this is an objective test because it says reasonable person. It doesn't matter what the defendant themselves thinks, that would be subjective. This is just the court applying this test and coming to a view. The case of Blythe and Birmingham Waterworks is the case we'd use to support the existence of this test, and as you can see there, the facts: a water supply company, the defendant, were under an obligation to lay pipes, provide fire plugs for putting out fires. There were statutory requirements for how this should be done, but due to extreme cold weather during the winter, one of these fire plugs came loose, causing flooding which filled the claimant's house. Now, should an inexperienced person, for example a learner driver, be held to the same standard as an experienced driver? Again, varying views that you might have. If I were to say, let's replace the word driver with surgeon, would your answer be any different? And I think all of us would appreciate you can't have 2 standards. If somebody gets behind the wheel of a car, whether they're inexperienced or experienced by many years, everyone has to pass their driving test, and the consequence of the damage that you could cause someone with a car if you hit them or crash into their vehicle is the same, isn't it? Just as it would be a surgeon. So there can't be 2 standards. This is the case we'd use to support that, Nettleship and Weston, learners judged at the competent, more experienced person always. And here, the claimant was trying to help the defendant with driving lessons. The defendant panicked at one point when she was trying to turn a bend and straighten up, and they ended up crashing the vehicle, hitting a lamppost, and the claimant fractured his knee. But of course, she would be judged, even though she's taking those lessons, at the more experienced person. So we've got 3 scenarios here that you might like to have a go and pause the video. I'm asking, is there an identifiable duty of care and breach? So for the first, we've got Johnny, an athlete, suffers a knee injury requiring specialist surgery. World-renowned surgeon conducts the surgery, but unknown to the patient, they have a drink problem and they cut a tendon, causing irreparable damage. Does Johnny have a claim in negligence? So we know, don't we, that surgeon and patient, there's already an existing duty of care regarding the welfare of the patient. Is there a breach? Well, we apply that test, the objective test from Blythe. We could say, has the standard of care fallen below what is expected of a reasonable person with regard to this surgeon? And I think clearly the answer is yes, because you'd never have somebody with a drink problem near an operating table. So at the moment, that's what we can say here. Now, I've referenced the case of Bollum, and I haven't talked about it yet. It's going to be in the next slide. There is a separate test for breach where it involves professionals, like a surgeon, for example. So I will come to that, but the same sort of principle applies. Now, the second scenario is 2 amateur footballers are playing in the local league when Paul commits a very poorly timed late tackle on Harry, an opposition player, causing him to suffer a double leg break. Does Harry have a claim against Paul? First thing we should note here is, yes, football's a contact sport, but depending on the circumstances, certainly and I've put here a very, late tackle, poorly timed, there is an argument that it could be something that you could sue in tort law for, that the other player's been negligent. At what standard do we hold that amateur player at? Well, if you remember the case of Nettleship and Weston, whether you're an amateur or more experienced, even like a Premier League professional footballer, the standard of care remains the same. So here we can say a duty of care exists, the welfare of players on the pitch. You could use the Kapara and Dickman three-part test if you're just, want to show more detail. But like I say, Nettleship and Weston, arguably yes, they will be judged, and it looks like there could be negligence there. Now, Terry, a 15-year-old boy, is out with 4 of his school friends to the local park. Messing around with his friend Josh, they begin to throw bits of wood and bark at each other. A piece of bark strikes Terry in the eye, causing a serious eye injury. Again, duty of care. I think probably if I was presented this in an exam scenario, I'd use the Kapara and Dickman 3-part test, because it's unclear to me. I can't think of an immediate existing statutory or common law duty of care. Question though of breach, we know the standard of care, if it falls below that of a reasonable person, would be a breach. But here, interestingly, Terry's 15 years of age, presumably being school friends, they're around about the same age too. A reasonable person is considered by the courts to be a person of the age of the defendant. So in other words, if I pop this up here, the defendant here, another school child, say, 15 years of age, presumably same age, they'd be considered at that age. And I think the courts appreciate that, children can be generally quite sort of boisterous, but also at their young age, they probably don't have full realization of what sort of risks could occur. And we see this in Mullins and Richards. In Mullin and Richards, we had 2 schoolgirls playing with rulers, sort of, I think, fighting one another or smacking them against one another. And one of the rulers broke and splintered, and one of the splinters embedded in the eye of the other schoolgirl, leaving her blind in that eye. And the courts said that a child would not reasonably foresee that such damage could happen. So that's worth bearing in mind. I mentioned before, if you're presented with a problem scenario that deals with a professional, and a professional is, well, what is a professional? It's certainly somebody who is qualified for the job, requires a qualification, certain level of skill or training, and we would accept, wouldn't we, that, surgeons, dentists, teachers, just to name a few, would be those that this would apply to. So rather than use the Blythe test of, as I said before, does the defendant's standard of care fall below what is expected of a reasonable person, there's a 2-part test. So let me put both up. Firstly, does the defendant's conduct fall below the standard of the ordinary competent member of that profession? It's very similar, it's just worded slightly differently, isn't it? So it's about measuring them up against the competent member of that profession. So if you're the claimant, you want the answer to this to be yes, it has fallen below the standard. Second question is there a substantial body of opinion within the profession that would support the defendant? And you want, if you're the claimant, the answer to be no, and therefore you've proven breach. So if we go back to the scenario of the surgeon with a drink problem, clearly, as I said before, no surgeon with a drink problem would be allowed to go near an operating table. So we know that, they're not competent, they're not able to do their job as effectively as normal. And there wouldn't be anyone the court could call up as another member of that profession that would say, you know what, it's absolutely fine if you've got a drinking problem, you can operate. So clearly, in that scenario from before, these 2 tests would pass for the claimant and you'd establish breach. On top of breach, what the court will also consider are something called risk factors. Now, in a problem scenario, you would have to decide which risk factors are relevant to discuss. Now, what this does is, as the courts weigh these up, depending on the case, if they are present, it may help them decide and help you decide whether there is a breach. So any special characteristics, now for example here, if the defendant is aware that the claimant has a special characteristic, for instance like a disability, if you're an employer and you make them aware of a disability and they then fail to look after your welfare and you suffer damage, then you could certainly say they're at breach. We see this in Paris Stepney Borough Council, because here there is a man who is employed by the defendants, and I think he's doing welding. The claimant himself, he's actually blind in one eye, and of course with welding you should be given safety goggles and equipment. He was given nothing, and of course when welding, I think hot sparks then went in his good eye, and he ultimately was left blinded for life completely. So clearly we can say that the employers were at breach by not taking into account his special characteristic. Second one, this one's quite common, so I would raise this probably every time. Size of the risk. The greater the risk, sort of, if nothing's done by the defendant, the more that negligence is established. So in Bolton and Stone, this involved a cricket club. Some cricket balls had escaped the cricket ground, and I think on this occasion had injured the claimant. And it was determined by the evidence that probably about 5 or 6 balls at most had escaped the cricket ground during play. Now, because that was so few in, I think, a period of 30 years, 5 or 6 balls in 30 years is so few, the size of the risk is small. So as long as the cricket ground had taken some reasonable precautions, that was enough. Talking of precautions, the court have to weigh that against cost and effort. So if we take the instance of the cricket club in Bolton Stone, the court could say, couldn't they, oh, you should have a roof installed on your cricket stadium, but that would most likely bankrupt the cricket ground owners. I imagine they wouldn't even be able to do it, so that wouldn't be reasonable. But if we take the example of Latimer and AEC, here you had a factory, there was flooding, the employees were concerned for their safety, so the employers, AEC Limited, mopped up what water they could and then put sawdust down to soak up the remaining excess water. And of course, when one employee did unfortunately suffer injury and try to sue, the courts felt that the employers, AEC, had taken appropriate precautions and therefore weren't negligent because they hadn't breached their duty of care. Also look out for, were the risks known at the time? If there's no knowledge that a risk exists, I'm talking about from a reasonable person point of view, then you can't hold them at fault. In Rowan Ministry of Health, I believe this is where anaesthesia at the time, this was the 50s, was stored in glass vials or test tubes, and there were micro cracks in the glass that then harboured bacteria that of course would affect this drug. So when the claimant was injected with the drug, this anaesthesia, it ended up resulting in a severe reaction and paralysis. So the hospital here, or the Ministry of Health, were not liable because that was the common practice at the time of storing the anaesthesia. No reasonable person would have known that risk could occur. And the last one, public benefit, Watson, Hertfordshire. Again, I think this was an emergency service trying to cut a person out of a vehicle, and they had to take some risks to try and do that quickly, which unfortunately didn't sort of succeed as they would have liked, and the claimant suffered harm. But the court accepted that in some instances there may be a public benefit to trying to take certain risks to do something. It's a very sort of unique kind of situation, and not one I often see in exam scenarios, but you may want to look at that, certainly in terms of emergency services. So we've got 3 scenarios here, and I'm asking you this time, duty of care breach, can we identify any risk factors? You're welcome to pause the video to have a look at this, but we're going to go through it now. Sandra orders a takeaway at an Indian restaurant. She suffers from a severe allergy to peanuts. She carefully chooses the meal. She tells the person about her order, about having this allergy. They say to her the meal is nut-free, but that's not true, and she suffers an allergic reaction and dies. Does Sandra's family have a claim against the restaurant in negligence? And I think here the answer would be yes. There is an existing duty of care. Again, making sure that the food, if you will, that you're providing to your customers is safe. The breach here, we're dealing with whether or not that standard of care has fallen below that of a reasonable person, and clearly we would say yes. And the risk factors that help determine that is, she had, Sandra, a special characteristic. She told them she had an allergy to peanuts. They then did nothing and she suffered harm. So therefore, that's a clear indicator of a breach. Size of the risk is relevant because, of course, those who have, for example, nut allergies, the size of the risk can be huge and it can lead to death. And that's, of course, what we have here. Precautions taken, well, they didn't, did they? They could have checked properly whether the meal had any nuts contained or any contamination, and they did neither. So here you've got a whole raft of risk factors then, and clearly the restaurant is in breach. The second one is a residential care home for the elderly has its heating break down during the winter. Employees use blankets and heaters to keep people warm until the central heating is fixed the next day. But unfortunately, Henry, one elderly resident, catches pneumonia. Now, does Henry, the elderly resident, have a claim? Duty of care, we could say clearly again, duty to keep their residents in the care home safe. Their welfare is important. Is there a breach? Has their standard of care fallen below what is expected of a reasonable person? We use the risk factors again to help, and I think here you can use two. We know the size of risk. Given that it's winter, gets very cold, elderly residents are vulnerable, so therefore they could suffer harm. But there isn't going to be any liability here because of precautions taken. It would appear that they have taken some precautions with those mobile heaters and blankets, and then they fix that heating the very next day. So I think that may be a strong argument from Latimer and AEC that there is no breach on behalf of the defendants. And then we have Penny, hired to cater for an end-of-year office party. Now, she provides a main course involving chicken, but unknown to those at the party, she's been storing it, improperly. Raw chicken and cooked chicken together. This cross-contamination leads to food poisoning. Do the partygoers have a claim? Now, again, duty of care. She has a duty of care to make sure the food is safe to those partygoers, safe to consume. Has her standard of care fallen below what is expected? You might even want to apply the professional test here, the two-part test we discussed, because you would have had some training and surely should be qualified. Either way, the risk factors here that help us. The size of the risk is huge because if you do cross-contaminate in that way, it can lead to potential death, if not serious injury. So size of the risk is huge. What precautions has she taken? She's taken none. So she should make sure the food, the raw chicken, the cooked, are in separate containers. They're not, going to touch one another. She's done nothing there. She's clearly at risk as well. Cross-contamination, Chef Gordon Ramsay often talks about this, and there's a YouTube clip there if you want to have a look at some instances where he discovers cross-contamination in other restaurants. So going back, remember of course that if you're the claimant, we're needing you to establish a duty of care owed by the defendant, that the defendant breaches that, and then finally damage. Now I described that as causation, and this is trying to establish that there is a causal link between the defendant's act or omission and essentially the harm you as the claimant have suffered. So there are going to be familiar sounding tests here from criminal law, but just be wary that the cases are different. There's factual cause and legal cause that needs to be proven for damage. Factual is the but-for test. But for the actions of, let's say, for example, in the last one, that chef. But for the actions of, serving contaminated chicken, would the partygoers have suffered food poisoning? And the answer's got to be no. In Barnet and Chelsea and Kensington Hospital, this was shown, interestingly, where a man was fatally poisoned, and he went to hospital complaining of ill health, and the doctor misdiagnosed, didn't pick up on the fact that he was fatally poisoned, sent him home with some other sort of advice, and he later died. And the question was the doctor at fault for causing his death? And the answer is no, because with the poison he'd been given, there was no medical treatment that would have saved his life. So while we might say her way of her doing a job, misdiagnosing, shows some incompetence, if you will, we haven't been able to prove damage, so she wasn't liable, or the doctor wasn't liable, I should say. We also need the legal cause. This is often referred to as the claim not being too remote, the remoteness of damage claim. And here we can see in the Wagon Mound, where we had the ship called the Wagon Mound, and I believe it started as it was in a wharf with other ships. Think of it like a dock with other ships. And whilst it was at the wharf, it was leaking oil into the water and mixing with other sort of cotton debris and other things. Now, just so happened that nearby, further along down the wharf, there was a third party that was welding, and those sparks hit the water and caused the water to catch fire, and then a number of boats were severely damaged. Now, the courts said that the claim there against the Wagon Mound was too remote, because really no reasonable person could foresee that water would have caught alight. It was kind of like a perfect set of circumstances. There may have been oil on the water, but in other days it would have just sat there and dispersed after time. But it just so happened that there was a welder further down. Now, you need to establish those two things, but depending on the problem scenario, you may come across this optional third test for legal, which is the thin skull rule. You remember that from criminal law. You take your victim as you find them, and in the Smith and Leach brain case, excuse me, you had an employee who I think was dealing with in the factory. I think it was a steelworks, smelting and other things, and yes, they were galvanizing steel. And unfortunately, as they stepped away from a protective guard, one of like a hot splash from the steel and the liquid they were using to galvanize it splashed up and hit them on the lip, and they suffered a severe burn. And that activated pre-cancerous cells. And I think within 3 years, the employee unfortunately had died. Now, of course, the employer wouldn't have known that he had precancerous cells or anything like that, but the fact is, for at least damage, you take your victim as you find them, and so they were held to be liable. There is a doctrine called res ipsa loquitur you may want to be aware of. This is situations where it's clear what the cause of the breach is. So, for example, here, if someone has an operation, the operation is negligent, and let's say a swab or some sort of equipment is left inside of the patient, resulting in them being in pain afterwards, then the patient doesn't know exactly how that duty of care was breached by the surgeon because they were unconscious, but obviously it's pretty clear that the swab inside of them that's been discovered is what's causing the damage. And this actually happened to a pensioner, Maureen Dealey. I've left a link there if you want to have a look. So in this instance, the claimant can raise this res ipsa loquitur. Roughly translates to mean the thing speaks for itself. They'll have to show, though, 3 things: that the defendant was in control of the situation which caused the injury. A surgeon would be, for example, in an operation. Secondly, the accident would not have happened unless someone was negligent. Well, leaving a swab inside somebody and sewing them back up is clearly demonstrating negligence. And thirdly, there's no other explanation for the injury. Well, of course, how did that swab get inside of you if not for the operation itself? If successful, the burden of proof will move from the claimant to the defendant. So whereas at the start, it's typically the claimant having to prove on the balance of, the claimant having to prove their case. Here, the defendant suddenly has to prove with evidence that they've not been negligent. So it kind of puts them on the back foot. Let's just have a look at 3 scenarios for causation then, or damage. The Ministry of Defence organised a night out drinking for their soldiers on their return in an army vehicle with a canvas roof. Smitty, a drunk soldier, decides to climb the roof to reach the back of the vehicle. He falls and is struck by a passing lorry. Does Smitty have a claim against the Ministry of Defence? So we're just dealing with damage here. What we would say here is, but for the actions of the Ministry of Defence organising this drinking night out, would Smitty have suffered an injury anyway? No, clearly not. Legal causation, is the claim too remote? Well, I think it's reasonably foreseeable that if you have a night out involving drink, such rowdy behaviour could cause some sort of damage, or in this case injury, to occur. Secondly, 2 14-year-old boys, Scott and Billy, find an abandoned boat, decide to do it up. The local council have placed a note on it saying it will, if not claimed, it will be taken away within a certain amount of time. It's not taken away. The boys, jack up the boat, lift it up, basically so that they can paint it and work on it. But the boat ends up falling on top of Scott, causing a paraplegia. So would Scott, who suffers this damage, be able to claim in negligence? Well, at least on the damage side of things, we would clearly say the factual cause is proven. But for the local council leaving the abandoned boat there, would Scott have suffered that injury anyway? Well, no. And secondly, legal causation, is the claim too remote? The answer is no. The fact that an abandoned boat, and by that very definition, has been left there, means that it could potentially be harmful. It's reasonably foreseeable that it could present some harm. Now, in your claim, you don't have to prove, in here, for instance, the local council specifically would have, realised it would have led to somebody's paralysis. Only, that harm is reasonably foreseeable is enough. Jenny, a mechanic at an auto shop, accidentally spills some petrol in the parking lot but fails to clean it up. Barbara, a customer walking across the parking lot, flicks a cigarette, hits the gasoline, resulting in a fire that burns Barbara. So does Barbara have a claim against Jenny, the mechanic? And we'll cut straight to it here. This is an example of, just like in criminal law and causation, an intervening act. Barbara, essentially, who comes along, is this third person. And Jenny, and indeed no reasonable person, I should say, no reasonable person would realise that Barbara would turn up and flick this cigarette butt towards flammable gasoline. So I think here it's clearly wrong to hold Jenny at fault for anything, and I think therefore the claim is too remote, just like in the Wagon Mound case. Some news stories that kind of illustrate a lot of what we're talking about. 2015, Alton Towers, the Smiler crash was widely publicised. 4 were seriously hurt. And I've circled this young lady just as an example, Vicky Bolsh, among 16 injured, when what had happened is, and there was an empty carriage stranded on this ride, and the operator of the ride, rather than wait until that had been moved or anything like that, started the next carriage full of people, and it ended up slamming into this empty one, of which Vicky Bolsh and others were at the front, and she ended up losing one of her limbs. 4 years after losing a leg, and 24 years old now, at least at the time I'm looking at this article, she reached a multi-million-pound settlement in damages. So you can see here, in terms of the need for medical treatment, a prosthetic limb, all of these things and subsequent operations, that has to be taken into account. Now, we're doing damages or remedies in a later topic, but just to also bear in mind, I said before that a claimant for negligence has to prove duty of care, breach, and damage. Be careful. It's just, damage means causation, and that's what you prove for negligence. Damages, that's with the S, refers to the compensation you could win. So just be careful not to make that mistake. Another example here, Pret allergy death. Unfortunately here, the young lady Natasha bought a baguette from a store and suffered an allergic reaction. There was no indication on the packaging that it contained the ingredient, or I think it may be nuts, in fact, that she was allergic to. Now, her parents fought for a change in the law, and now under Natasha's law, this is 2019, food businesses will have to include full ingredients labelling on pre-packaged food. Defences then to basic negligence. There are two. The first is consent, otherwise known as valenti non fit injuria in Latin. Referring to its consent is fine. Now this is a full defence, and this is where the victim accepts, voluntarily. They voluntarily assume the risk of harm. Now, as the defendant, you have to establish three things with evidence: that the claimant had knowledge of the precise risk involved, that they exercised free will, and they voluntarily chose to accept that risk. So, again, as an example off the top of my head, if somebody gets into a car with somebody, for instance, that is drunk, and doesn't choose to wear a seatbelt or something like that, then again, you could maybe argue, if you were that driver, that they consented to that potential risk. Contributory negligence, I put it as a partial defence. It kind of is and isn't. It comes under the statute of the Law Reform Contributory Negligence Act of 1945, and what this means is any damages awarded to the claimant can be reduced according to, from the court's point of view, how much the claimant has contributed to the damage they've suffered. So if I just take the vehicle one again, if let's just say if there's a person driving negligently, speeding, crashes into a vehicle, the person in the other vehicle suffers harm, but if they weren't wearing their seatbelt, then obviously the harm that they've suffered would be greater, and therefore they've contributed to the fact that the harm is worse. So they may win their case, but the amount of damages they'll receive will be lowered to reflect that. And an example finally of contributory negligence in the news, we've got here a very interesting one. We've got a cyclist on the left there, that the man and the woman who crossed the road. The light was green for the cyclist, but she crossed the road too busy on her mobile phone. He was shouting, he was sounding his horn, he couldn't swerve past her in time, he hit into her, and both were knocked unconscious. Now the judge here actually said that as the cyclist, he owes a duty of care to road users to drive with reasonable care and skill, and should in fact be prepared for the unexpected, whether that's someone crossing out in front of you or whatever. However, though she won her case against him, the court rightly recognised that she was at fault for being on her mobile phone and crossing out into the road and not paying attention, so therefore reduced her amount of damages. In terms of analysis and evaluation then, assessment objective 3, remember this can come into any problem scenario in AQA, although typically the 15 marks question is where we find this. I've already touched on this, but you can have a look. I've chosen the first bit about how the courts are reluctant to impose a duty of care on public authorities such as the police. We talked about that earlier because they felt that this would hamper the police's ability to do their job if they were fearful of always being sued, if they didn't, prevent crime. And the second one I chosen there is for damage or causation, and the wagon mound case. Remember, if you're the claimant, to prove a successful claim of negligence, you have to prove that the damage was reasonably foreseeable and the defendant caused it. And as I said, with the wagon mound case, they couldn't prove the claimant that the owners of that ship that leaked oil into the water were at fault. because of course the claim was too remote. No reasonable person would have foreseen the water, with the oils setting alight because of these welders that were nearby. So remember, for negligence, for someone to be at fault, you have to establish legal causation, factual causation, and it has to be, for legal causation, reasonably foreseeable. Okay, thanks very much. Another video done, and I'll see you for the next lesson for psychiatric injury. Good luck with your revision.